Hi, I'm Barbara Dunn, an attorney that works with groups in connection with their meetings, travel, and hospitality contracts.
And I'm Lisa Sommer Devlin, an attorney that represents hotels and resorts regarding convention and group-related contract matters.
And together, we're Legalease with the Ladies, powered by HopSkip.
In this video, we're going to talk about dispute resolution. If you have a contract that doesn't say anything about what happens if the parties are in a dispute, that means that they're going to have to go to court if they're unable to reach an amicable resolution. Many contracts include specific clauses as to dispute resolution to provide guidance for what will happen. Some of those clauses simply say what state's law will apply. Usually, if there's nothing about that in the contract, the law would say that the law of the state where the event is supposed to happen would be the applicable law, but parties can always agree on a different state's law if they'd like to. They also can agree on what court might have jurisdiction over the event, or they can agree on alternate dispute resolution methods. Typically, that would either be mediation, which is a formal kind of settlement negotiation meeting, or arbitration. I personally really like arbitration instead of going to court. For the first reason, court resolution takes a long time. In most states, it'll take you 2 to 3 years to get to a trial simply because of court backlogs. And that backlog has only gotten longer as a result of COVID-19. Courts that were closed in 2020 are going to have to make up all of those days that were lost for trials, motions, other kinds of things. And under the law, criminal cases get preference because of speedy trial requirements. So if you are going to court over a contract dispute, you're going to be waiting a long time to get a resolution. And many of us have heard that old saying, justice delayed is justice denied. And I really agree with that. When you're in a commercial dispute setting, you want to get a resolution as soon as possible, which is why I like to include arbitration clauses. Arbitration can be done in many different fashions, but there are professional arbitration companies that have trained arbitrators that essentially serve as a private judge. The parties agree to resolve their dispute by going to arbitration, similar to Judge Judy, only with usually a former judge. And it's like a mini trial. You sit in a conference room instead of a courtroom, but you still have formalities like a trial. There's witnesses, there's documents, there's all those kinds of things that happen. And then the arbitrator can issue an award that can be either a reasoned award where they give their reasons for why they ruled as they did, or they can just simply say who won and who lost. A lot of people think that arbitrators split the baby. They kind of end up somewhere in the middle. That's not been my experience. Most professional arbitrators are retired judges, and they take their obligations very seriously, and they give the parties a good hearing, and they come up with a good result. I like arbitration. I think that's the way to go. I know some people disagree. Barbara, what do you like to recommend to your clients?
Thanks, Lisa. Well, first and foremost, informal dispute resolution, as I know you agree, really is important, and that it really does boil down to the parties properly communicating what in fact is in dispute. No surprise to our listeners today that most disputes involve money and the payment of money, whether that be for attrition fees or cancellation or anything along those lines. And so it is important for the parties to articulate that dispute. I encourage my clients to notify the hotel if there are charges. Let's say it was a meeting that occurred and the group has charges that it's disputing, that it notify the hotel in writing of the disputed charges, but most importantly, pay the undisputed charges. I think that's always important because nothing's going to get you into a pickle quicker than not paying undisputed charges. So that's first and foremost. As to the type of resolution, I represent a range of groups from nonprofits to for-profits. So every company, every organization has a different thought and strategy. Many of my clients, their in-house counsel might prefer arbitration or prefer litigation. So from my standpoint, again, that informal dispute resolution is the best. Honestly, I'd rather keep dispute resolution beyond that silent, because we don't know what the dispute is going to be tomorrow. And we're agreeing in the contract to sort of tie our hands today to that dispute that we don't know what it is tomorrow. Having said that, I know it's important to the hotels, and again, it may be important to the groups. One thing to note about arbitration is that it's private. So typically the parties, it's a private filing. There's not necessarily a public notice of a filing. Contrast that with litigation, when in fact filings are typically public in that way. I bring this up to say that certainly I know it's never the hotel's desire to sue a group. And certainly a lot of groups will say, hey, if you sue us, I'm going to take to the airwaves and tell everybody that you're a bad hotel. That's not always the case, but it does boil down to that. And so I think having a dispute resolution provision that is acceptable to the group and the hotel is a good strategy. That might mean just leaving it at informal dispute resolution, and then later saying to the parties, hey, let's agree to mediate, or let's agree to arbitrate. But I think it's important to have at least a placeholder in there on the informal side. And I think in particular, Lisa, you and I have dealt over the years on a variety of disputes across the table. Having that cooling off period, I think, is really important because often in the heat of the moment, things are said or done in haste, and that isn't necessarily the way they want it to be. And I think often that let it marinate, right? The cooler heads prevail, let time go is a good strategy for dispute resolution. And I know, Lisa, certainly the hotels spend a lot of time and money over dispute resolution arbitration, and they would also prefer informal dispute resolution.
I don't disagree with Barbara on informal dispute resolution. I think that's a great way to get things done. Many clauses will say that the parties agree to submit the matter to their senior management. I just like to have something specific in the contract, because I always joke that once the parties are mad at each other, they're never going to agree on anything. And so if you've gone through that informal dispute resolution and can't reach an agreement, and one party says, let's arbitrate, the other party is going to say, anything you want to do, I don't want to do. So that's why I like to include a clause. Another thing to think about in your dispute resolution is whether or not you want to address attorney's fees. I, again, promote using attorney's fee recovery clauses, because that way the party who wins in the dispute, whichever side it is, gets reimbursed for their fees, and then they are completely reimbursed for everything that they put into it. In most states, there are variations, but in most states, if you don't say anything about attorney's fees, then each side pays their own fees. So if you win $100,000, but it's cost you $50,000 in arbitration or court fees to get there, you're only going to net $50,000 unless you have a recovery of attorney's fees. So that's something I like to include, although I know other people are more sensitive to including attorney's fees. Barbara, what do you like to do?
Yes, Lisa. So as you mentioned, in the general rule in most states is that each party pays their own attorney's fees. And I tell my group clients, that's the way you really want it. If you really want to gamble on attorney's fees with the risk that you might have to pay twice, your attorney's fees and the hotel's attorney's fees. Where I see this come up isn't at the courtroom level or the arbitration hearing level. It's at the settlement level. It's the parties working toward reaching a number. Let's say it's a dollar amount in dispute, and the hotel might move down and the group might move up. But at some point, the parties are going to say, look, I don't have to move up or down anymore. I can sue you tomorrow. I can go to arbitration tomorrow. Judge Judy will declare you're the winner, I'm the loser. So you better pay more money now to avoid a dispute later. And that strong arm tactic is something that happens. And I acknowledge that it can happen both ways, because typically the prevailing party attorney's fees clause does run both ways. But I also remind my group clients that, again, most disputes involve money. And in many cases, the hotel might be deemed to be the winner, even if they're not going to recover the full amount. Let's say it's a cancellation fee or an attrition fee situation. If they recover even a portion of that amount, that might deem them to be the winner. Therefore, you're the loser, and you've got to pay twice. And I agree that that risk is there as a way as well, as you mentioned, Lisa, for the parties' incentive for the parties to settle. But I've seen it used in that manner, and that's been problematic for groups.
So as you've gone through our videos, you've probably seen that Barbara and I agree more than we disagree on hotel contracting matters. But in this case, you can see that we have differing views for differing reasons. This is something that you're going to need to review with your own personal counsel to determine what's going to be best for you and your position. And it may not be the same in every contract that you enter. It may depend on a lot of different factors. But you need to keep in mind that all of these things are things that you should be consciously considering, not just ignoring in your contract.
And Lisa, just in closing, I would say that, in many of the disputes that come up in our industry, certainly those arising out of COVID-19, when I flip to the contract, I'm not necessarily looking at the force majeure clause. I'm looking for an arbitration clause. I'm looking for a prevailing party attorneys clause, because that also sets the stage. So I can't agree with Lisa more that you need to talk with your legal eagle that help you formulate what the best resolution, the best dispute resolution provision would be for your organization, and work to negotiate that in the contract. This has been Legalease with the Ladies, powered by HopSkip. Please leave your comments and feedback below, and feel free to subscribe to our channel. We look forward to being with you again.